Supreme Court Thursday rejected an effort to undermine the power of the Consumer Financial Protection Bureau. The agency was created after the 2008 financial crisis as a way to protect consumers from unfair financial practices like deceptive mortgage lending or excessive credit card fees, things that contributed to the economic crash 16 years ago. The issue brought before the Supreme Court was over how the watchdog agency is funded and therefore who's got a say in its affairs. The CFPB is funded through the Federal Reserve System as opposed to congressional appropriations. It was set up that way to protect the agency against the impulses of a partisan government legislature. But some opponents say that allows the CFPB to operate without oversight by the people's representatives. The Federal Reserve Board, the FDIC, and the Social Security Administration are funded in a similar way. CBS News legal contributor Jessica Levinson joins me now. Jessica, it's great to be with you, as always. Okay, before we get into the details of the case, can you help me with the larger tension that is at issue in this case? Is the tension that agencies of the federal government should be independent to do their work, but not so independent that they are delinked from the will of the people? Or is it something else?
No, I think that's exactly it. As you know, this is part of a broader effort by conservatives and others to try and weaken the power of these independent agencies. There's a number of different executive agencies cases before the Supreme Court this term, and they're all asking different questions about the same broad issue, which is how much power are we comfortable with these executive agencies having? They're created by Congress largely, and they operate somewhat independently. And so how independent do we want them to be? On the one hand, you could say nobody elected the people who run these particular agencies. They're not directly accountable. Are we giving them too much power? On the other hand, you can say we don't want them to be subject to the whims of our lawmakers who are many times up for election every 2 years.
And so what in the Constitution gives the CFPB independence from the congressional appropriations funding, which regular folks, including me, might think, wait a minute, there's a way it's supposed to go through Congress. Why does it get a special route?
As you said, and I thought this was so clear in the introduction, there's a couple of different agencies that get an independent route or a separate route. And that's because we're particularly worried about Congress saying, you know what, we don't like you very much anymore, so we're going to defund you. You know that there are these big conversations about potentially shutting down the government every time we need a new budget because it's so contentious. And the Consumer Financial Protection Bureau was set up so that it wouldn't be subject to those political winds. And you do that on the state and local levels when it comes to similar types of organizations and specifically ethics commissions, where you think politicians might want to kill those commissions. So what allows that to happen is the way that the legislation that created it. Now, the question before the court today was, is that legislation okay, or does it fly in the face of the Constitution and specifically the Appropriations Clause?
And so then what did the court find? And should I be fascinated that Judge Thomas wrote the opinion, or will you say, no, this is obvious, he talks about this all the time?
No, it's fascinating because it's Justice Clarence Thomas for a 7-2 majority, and then it's Justice Alito and Justice Gorsuch as the two dissenters. And what's fascinating to me is that both of them are saying, I'm the real originalist. I'm the real textualist. If you look at the Constitution at the time that it was written, here's what the founders would have intended. So it's this fascinating conversation that the two wings of the conservative party, the conservative justices, are having with respect to how best to read the Constitution. Justice Thomas says, I'm looking at the text, I'm looking at the history, I'm looking at tradition. That's all we can look at. And the Appropriations Clause just says you need to find a source of funding and a purpose for that funding. Justice Alito in dissent says, I'm looking at the Appropriations Clause, and there's no world in which the founders would have been comfortable with an executive agency having this much independence and this type of funding. So it's a fascinating dialogue. Essentially, will the originalists please stand up? Because they're having very different conversations.
And so in this conception, though, how does the CFPB, how is oversight exercised once it gets going?
So there is oversight actually in the sense that part of this effort to try and undermine the power of the Consumer Financial Protection Bureau was a case that was decided about 2 years ago that dealt with how much power the president had to oversee the director of the Consumer Financial Protection Bureau. And that case said that the way the director was appointed and the job protection that the director had was actually unconstitutional because that person had to be able to be fired essentially at will. So you still do have the director and other members of the agency that are accountable to elected officials, but it is true that their funding stream, as long as the legislation stands, is more protected than that of other agencies.
Jessica Levinson, as always, a delight. Thank you so much. Very helpful.